Good evening, everybody, and thank you for participating and thank you for inviting me. I congratulate the team of Victory Result for taking this initiative. And the proposed bills which have been introduced in the Parliament are of seminal importance to the criminal justice system of our country, because the reform which has been proposed in these bills is in the nature of completely overhauling the entire criminal process. The attempt is to bring the system up to date. What we were trying in past was having things in piecemeal manner, wherein we were doing certain amendments in the act. But now, with this complete overhaul of all these three acts, the entire mechanism is being attempted to bring with the present times. And I will deal with most relevant provisions which the amendment have been enacted. I can say the majority of the amendments have been done in the Criminal Procedure Code, which is now would be termed as Bharatiya Nagarik Suraksha Sanhita. So whenever this would come into force, because as of now, I must also give you a brief background that how all this started. In 2020, a committee was constituted by the Ministry of Home Affairs. It was headed by Professor Ranveer Singh. He's a well-known academician in the field of legal knowledge, legal awareness, and as a professor of NLU. Mr. G.S. Vajpayee was also there, another very reputed professor. Mr. Mahesh J. Tiwalani, a well-known senior advocate and a member of parliament, and one retired judge, Justice G.P. Thareja, were part of this committee. This committee was constituted to give a report after taking suggestions from general public, individuals, and agencies, everyone. And the platform was open to all whosoever wanted to give their suggestions. The suggestions were taken by the committee, and the committee's mandate was to give a report on the changes with regard to bringing the criminal justice system in conformity with the present times. It was an exercise done to completely overhaul the criminal justice system. So with this mandate or with this remit, the committee started to function, and the committee started, I think, if I remember correctly, the committee started functioning somewhere in the May of 2020. And the committee has given a report. And after that, the Minister of Home Affairs on 11th of this month has submitted this report, this bill to the Parliament, and now the Parliament has referred all these three bills to the Standing Committee. The Standing Committee is again headed by a former IPS officer who is currently also a member of Parliament in Rajya Sabha, Mr. Brijlal. He was former DGP of State of Uttar Pradesh, a very well-known and a decorated officer. So now let us examine that what does these three bills, and primarily because the majority of the changes, as I've told earlier, are effected in the Criminal Procedure Code. In that, 160 sections have been changed, 9 sections have been added, and 9 sections have been completely repealed. So, and the CRPC now is of 533 sections. Similarly, in the IPC would now be called as Bharatiya Nyaya Sanhita Bill. Instead of 511 sections which used to exist, the sections would now be 356. 175 sections have been amended, 8 new sections have been added, and 22 sections are repealed. The least number of changes are made in the Indian Evidence Act, which is now called Bharatiya Sakshya Bill. So Indian Evidence Bill. So the definition is same. It's just the Hindi word is used, Hindi language is used. Instead of 170 sections, now 167 sections would be in the Evidence Act. 23 sections are changed, 1 is added, and 5 is repealed. So in this session, I would be concentrating minimum on this particular act, because there are not major changes which are made to this act. Majority of the time, I think we would be taking with regard to the CRPC, because it has far-reaching changes which are in the nature by which the conducting of a trial, investigation, and the issuance of summons, judgments, and everything is open to complete overhaul. Police, there is power to issue arrest, and multiple things have been changed. So what I am planning and what I intend to do today now is I would deal with the sections which are new to the CRPC. Other what has been done is that majorly the sections have been renumbered. The sequence has been changed. The new aspect is the sections which have been added, or the provisions which are added in an existing section. Some new subsection are added, provisos are added. So I would be concentrating on those parts because this is something which is new. All other sections are already existing. There is enough law available on internet, and access to that is available to everybody. So that is not required to be dealt with, but the new aspect would be dealt with. And I must say which are these sections which have been changed or added. We start from clause 86, 105, 106, 107, 112, 113, 172, 336, and 556. So these are the sections which are completely new sections. They have been added, and I would be dealing with them. We will quickly run through those sections in order to understand what are the changes which have been made. So firstly, let me just start with section 86, and this would be as of now referred as a clause because the bill has not received the assent of Parliament and has not been gazetted and approved by the President of India. So therefore, it is still referred as a bill. In clause 86 is with regard to the identification and attachment of the property. Now, what happens when during the investigation, the person has derived any property out of committing any crime, or it is a proceed of crime, then there is a requirement and a procedure available in the code that the police officer can attach the property of that person. Now, what is important in this is this has to be done in the form of a written request, which has to be done. And what this section 86 now does is this, that even the properties which are in some other states, some other state as a state, different country, not a state of our own India, states of different countries with which we have treaties, a contracting treaty, the police has been given power, subject to the approval by the magistrate, that they can also identify those property, and those property can also be attached for the purposes of investigation and trial. This is very important, and this is in terms with the law, the proposals which have been given in UN. There are treaties which have been entered with the international communities, and we can now say that we are trying to bring our criminal procedure code at par with that. So now what section 86 says, section 86, clause 86 says that the court may, on written request from a police officer not below the rank of Superintendent of Police or Commissioner of Police, initiate the process of requesting assistance from a court or an authority in contracting state for identification, attachment, and forfeiture of property belonging to a proclaimed person in accordance with the procedure provided in chapter 8. Now, what is important in this is that the court has to start the process only on the written application from an officer not below the rank of Superintendent of Police. And Superintendent of Police in states is SP, and when it comes to metropolitan cities like Delhi, Mumbai, and all those big cities, it is the Deputy Commissioner of Police, which we know as DCP. So a DCP level officer has to give a written request that we have identified property of a particular offender, of a person which is beyond the country, and we have a contract or a treaty with this particular nation. So if under that treaty, that property can be attached. So a magistrate or a court of judicial magistrate may proceed to pass an order attaching the property which is even beyond the jurisdiction of the court. So this is something which was not available in the current code, criminal procedure code, which we were following. What used to happen, that we have seen in practical purposes, that now the accused of majorly of economic major big economic offenses will not use the money or the proceeds of crime to invest or purchase something in India, because that can be easily ascertained by the police officials or by the investigating agencies. So a new tendency had developed, or a new modus had developed, that they would invest or use that money to purchase a property or an asset abroad within territorial limits of this country. So this has been rightly noted by the legislature, that now this has become need of the hour, that a procedure should be there where the property which is even beyond the territorial jurisdiction of this country, we should have power to confiscate and attach that property. Similarly, and this is, as I have told you earlier, this is in conformity with the international covenants. The United Nations has already passed these kind of laws. Multiple countries are having these laws. It was only us that we were not able to amend this thing properly. And another, now I will be skipping to the second very important amendment, is with regard to clause 105 of the act. This deals with the search and seizure by the police official. We all know, and any lawyer who has practiced on criminal side would know, that search is the procedure which is most misused by police officials. In search, they would plant illegal commodity on things. They would recover something, some illegal or maybe a weapon of offense or something of that sort from some other place, but will plant it on the accused to show his complexity, to show his participation in the offense. So all these things we have noted, there are multiple judgments, multiple acquittals have happened on this point, that the such proceedings were not conducted properly. So this was something which was not being useful for even the prosecution and on by the accused, because what was happening, if your such proceeding is disputed, the benefit goes to the accused. So now, in order to overcome this lacuna, the legislature has now intended to amend, to include section 105, which is very important. It is considered, and it is like that a police officer is now under an obligation to record the procedure of search. He would, if he is going to raid someone or is going to search someone, then he has to record the entire process on a video. And for the convenience and looking at the infrastructure in our country, because all these police officials do not have their body cameras like the other developed countries, the provision has been made that the recording by a mobile phone would be sufficient for this purposes. So the clause 105 says the process of conducting search of a place or taking possession of any property, article or thing under this chapter or under section 185, including preparation of list of all things seized in the course of such search and seizure and signing of such list by the witnesses, shall be recording through any audio, video, electronic means, preferably by a cell phone, and the police officer shall without any delay forward such recording to the district magistrate, SDM or judicial magistrate of first class. I can say from my own personal experience and the stories which we have heard in the bar, that this is something which was misused by the police, and I personally believe this is one of the most commendable part of this act, that you are forcing the police officials to make a recording of search and seizure. This is going to go have a very long and a very far-reaching effect on the process of fair trial and fair investigation. Now, after this, what would happen to that search, the property which has been seized or in delay, because this property has to be sent to a judicial magistrate or a subdivisional magistrate or a district magistrate. So this reduces not only the possibility of making a false search or false planting of an article or a illegal commodity on an accused. It also provides an opportunity to the prosecution to have a fair trial in a matter, because it is a cardinal principle of our criminal procedure code that the prosecution has to be fair. It cannot be that the prosecution will start concealing material, will start not providing the correct evidence on record, which used to happen until today it is happening. And similarly, A new provision subsequent to this has been added, which deals with the attachment and forfeiture of the property. And this again is very important, because this has a very unique thing in this, is with regard to that when a property is attached. I'll go on section 107, clause 107. This gives the power to the police official that a property which he suspects is derived out of the proceeds of crime or is result of a criminal activity, then he can approach the court. Again, application has to be through a superintendent of police or a DCP, to make an application saying that this property is required, it has to be seized because this property is a proceed of crime, or this property has been purchased or obtained in view of the illegal activity. Now, what is important in this is this, that this can be done even during the pendency of the investigation. The magistrate can issue an order of attachment. Of course, the section requires that the person of whom the property has to be attached would be given a right to hearing. He has to respond within 14 days that your property, so and so property, has been sought to be attached by the police. What you have to say. So after hearing that person whose property is likely to be attached, the court may or may not pass an attachment order. This is something very important. And what is very I think I should say something which is going to help the speedy trial is a limited number of time given. It is only 14 days, and the person is, the word used is shall. So it is a mandatory provision. The magistrate does not have any jurisdiction to pass it beyond 14 days. Now, another very important aspect of this particular section is the ex parte power of a magistrate to order attachment. So subsection 5 says, notwithstanding with anything, if the judicial magistrate is of the opinion that the object and the purpose of making that attachment would be defeated, he has the power to pass an ex parte order attaching that property till the disposal of the application. So what it does, it protects the interest of both the parties, prosecution and accused. See, what will happen if police officer files an application and says, I want this property to be attached because it is directly a proceed of crime, and a time of minimum 14 days has to be given. So in that 14 days, if police officer is able to show that the person is trying to create a third party right in that property, or is he disposing the property, or somehow alienating that property, the magistrate can pass an ex parte order saying that, I'm sorry, this cannot be done, and you are forthwith restrained. It's like a civil court power of passing ex parte interim injunctions. So this is something which has been added in this provision which has far side effect. Another very important aspect of this provision is the power of judicial magistrate to direct distribution of such property to the victims of the crime. We have all seen, if someone is charged with an offense, if my money has been cheated, if money has been looted, I would be complaining and contesting that offense or trial against the accused for years and years to come, but I don't know whether I will get that money or not. So this provision tends to do this, that once a property has been attached and it has been proved that it has been made from the proceeds of the crime, the magistrate has the power to make distribution to the victims of the crime. And what is the procedure which has been adopted? The procedure is that the magistrate has to direct the district magistrate, that is the DM, the IS officer who is in charge of that area, under whose purview that property comes, to rateably distribute. Rateably is a word which is used that if I have suffered loss of 20 lakhs, I would be paid back rupees 20 lakh, and any person who has suffered loss of more or less would be paid equivalent to the amount that for which he has maybe cheated, or the property has been taken away, or the crime has been committed. So this is very important, that the magistrate has been given this power to pass such directions to ratably distribute these properties. Now, after this, section 107, clause 107, the another important amendment which has been effected, or an amendment which I mean a new provision has been added, is added in clause 112. So clause 112 deals with letters of request to investigate beyond the country. Now, previously, there was an existing power to have LORs, which this is called letter of request. In common terminology, we use the word LORs. LORs power was always there, but what was happening, that the power was not clear, and it was not in conformity with the provisions or the international treaties. So now what they have done, that they have included this new provision in order to bring clarity. And what they have done, and I'll read this provision because this is very important in order to understand how far-reaching effect this is going to have on the investigation and on the trial. Such clause 1112 says, if in the course of an investigation into an offense, an application is made by the investigative officer or any officer superior in rank to the investigating officer, that evidence may be available in a country or a place outside India, any criminal court may issue a letter of request to a court or an authority in that country or place competent to deal with such request, to examine orally any person supposed to be acquainted with the facts, circumstances of the case, and to record his statement made in the course of such examination, and also require such person to produce any document or thing which may be in his possession pertaining to the case, and forward all the evidence so as to take and collected or give the authenticated copies thereof, or things so collected to the court issuing such letter. So what is very important in this is that the police officer has been given the power to coordinate with the court and the authorities situated in a third country, and except arrest, he can investigate, record statement, seize the articles, or take possession of goods, and the person against whom this has to be done, he's duty bound to follow this. And what is another very important aspect is this, that all this document which has been collected, or the evidence which has been collected, or the document which has been seized, has to be transmitted to the court in India for the purposes of use in the trial. Now, what is the subclause 3? Another very important, subclause 3 is a deeming provision. It says any evidence and material which has been obtained by the process which is under subsection 1 of clause 112 would be deemed to be an evidence collected during an investigation. So we were dealing with clause 112. Clause 112, as I said, subsection 3 gives the deeming effect, that whatever evidence has been obtained from a third country would be deemed to be an evidence to be used in a trial to be conducted in our country. So this was non-existent in the previous criminal procedure code, and I think in the circumstances in which we are living today, and we have seen most of the offenders who are running away or who are purchasing properties abroad are not subjected to the rule of law or the process of law in our country. So this would again have some effect of making the law applicable to them and making them answerable to the law. Same letter of request from a country or place outside the India. So now this is our corresponding change which has to be made in our system, that if our investigating agencies can request the third countries to investigate, to seize evidence, to collect evidence, same principle and the same process has to be given by India to third countries with whom we have those contracting the treaties executed in accordance with law. So this is similar. We can just go through this, and after 113, the next amendment which has been made is made
or the next, see, amendment when I mean a new insertion has been made. So the new section which has been inserted is clause 172, and I'll also deal that how it is if some provision or some part of provision was already existing in the criminal procedure code which is prevalent today. So I will also highlight that portion, that this particular aspect was also present in the criminal procedure code which we have today. Now this one, clause 172 has been included to make the directions which are issued by police officials mandatory in nature. Previously, there was a provision to this effect that we were duty bound to comply with the direction issued by the police officer, but that was only limited to the aspect of providing evidence or providing information with regard to the commission of any offense. Now, under the section clause 172, a provision has been made in the new act, and section 153 of CRPC has been deleted. Because of insertion of this section, the previous provision which deals with the power of police officer to give lawful directions, that has been deleted and this provision has been added. And it says that all persons shall be bound to conform with the lawful directions of a police officer given in fulfillment of his duty under this chapter. Any officer may detain or remove any person resisting, refusing, ignoring, or disregarding to conform any decision given by him under this section, and may either take such person before judicial magistrate or in petty cases release him when the occasion is past. So now, we all have seen the protest which happened on road. So suppose there is a protest which is going on, and there is an important function or a government official or a third party as in third nation official is passing from that area, and the police officer thinks that for the safety of that person or of that organization, it is necessary that the persons who are protesting should maintain a proper distance or should go to a far distance or maintain a safe distance from that particular person so they can pass an order. But as we have seen that these kind of directions may not be complied and the police may have to use the force. Now what this provision does, that for such scenarios, the police officer has been given a power to detain a person for a particular or for a small period of time. For example, a rally is going on, and or maybe a yatra is going on, and some people want to create some issues in that yatra. What police officer can do, that these people can be detained and they can be let off after that yatra has passed or that protest rally has gone. So this is only to ensure that there is a proper law and order situation. This is not something which deals with the inquiry or trial or investigation. This is something to maintain law and order, because CRPC has provisions which also deal with the maintenance of law and order by the police officials. So this is very important. And there was another section 150 and 151 in CRPC, which has been retained. It is called 107 151, which is used in cases where there is a fight between two groups, and because of that the peace is likely to get affected in that area. So in that, the police officer has the power to arrest that person under section 105, 107 and 151 and produce them within 24 hours before the ACP, executive magistrate, who is generally the ACP of the area, and the ACP would release them after obtaining a bond of peace, that they will maintain peace in the area, they would not indulge in any violent act. So these kind of the provisions are there. So in addition to that, in trying to bring the situation in conformity with the current scenario, this particular amendment has been done. The section has been added, and after this, another very important part has been added in section clause 336, which is very important as far as, and I'm sorry, before we go to 336, I would request you to kindly deal with section clause 173. What this does is, I think most of the law students and even the lawyer in the gathering would be aware that in terms of the Lalita Kumari judgment, which was delivered by the Supreme Court, if any cognizable offense is disclosed, the police officer is duty bound to register the FIR. What was happening, that multiple complaints were being given to police officials, which was saying that yes, there is a commission of cognizable offense, but that was not clear. But the judgment of Supreme Court left no scope with the police officer to conduct some kind of inquiry before straight away registering that FIR. So now the amendment has been done to the section 154 of CRPC. Previous section 154, which is prevalent now, section 154 has been renumbered as section 173. And in that section 173, sub-clauses have been added to overcome this lacuna that the police did not have any authority to conduct a preliminary inquiry before registering the FIR. But this power has only been given to the police to petty offenses which are punishable up to 3 years. So if I disclose a cognizable offense which is punishable with more than 3 years but not more than 7 years, then they have to directly register the FIR. But if the offense is something which is in which the punishment is 3 years and maximum up to 7 years, then the police has the power to conduct a preliminary inquiry. What section says, and it is very important, that the preliminary inquiry can only be conducted with the prior permission of the ACP of that area. It is not that the IO or sub-inspector level officer or assistant sub-inspector level officer can conduct that inquiry on his own will. He has to first obtain permission. And if the permission is denied that no, there is no need to conduct an inquiry, you straight away register the FIR. Then he has to register the FIR. But a window has been given to the police officer to see whether a preliminary inquiry is important to disclose commission of offense. Because what happens, I'll tell you a practical situation, what really happens. Most of the, in situation where the transaction is in relation to money, if I have given some loan to a person or someone has taken loan from someone and the recovery is not made. So what is tried to be done is to convert that civil dispute into a criminal dispute, only to ensure that the recovery of money is done. And this is happening, sadly, this is happening because our civil recovery system, that the recovery by way of civil suits or those proceedings, they have become completely redundant. They take years and years. If I have to go to a civil court to seek recovery of my money which was paid to a friend or maybe some loan, it will take years for me to recover. So a short circuit has been developed to convert those civil disputes into criminal proceedings and pressurize the person who is now prospectively an accused to pay money back and settle the issue. So therefore, this is an excess burden on criminal justice system, because primarily this is the responsibility of a civil court to ensure that money comes back, a decree is passed expeditiously. This is not something, offense against the state. This is a private issue, a private loss to someone. So using state machinery for these kind of offenses may not be correct, but this is happening. So in order to balance this thing, this provision has been added, and this provision reads as under: without prejudice to the provisions contained in section 175 of the CRPC, on receipt of information relating to commission of any cognizable offense which is made punishable for 3 years and up to 7 years, the officer in charge of police station may, with the prior permission of the officer below the rank of DSP. So DSP in metropolitan areas would be ACP, considering the gravity of the offense, to proceed to conduct a preliminary inquiry to ascertain whether there exists a prima facie case for proceeding in the manner within period of 14 days. So within 14 days of the receipt of the complaint, you have to obtain the permission from the ACP, and then if the permission is granted, only then you have to conduct a preliminary inquiry. If the permission is declined, you are duty bound to register an FIR and investigate the matter in accordance with law. So this is something very important which has been done, because the lawyers who are practicing on criminal side would be noticing that the number of complaints of civil issues being converted into criminal FIRs or maybe criminal prosecutions was increasing. And there have been multiple judgments of late by Supreme Court saying that there is no need to convert civil disputes into criminal matters. You should go to civil court and get a decree, follow the law, and do whatever is required. But to use this criminal machinery to exert pressure on someone has to be criticized, and this leads to a lot of pressure and uh, undue humiliation, because what happens once an FIR is there against you, you're likely to be arrested. And knowing the nature of police in our country, they would first arrest that person and then look for evidence. Whereas it has to be other way around. First you look for the evidence, then if evidence is sufficient, you go and arrest that person. In our country, a reverse system is being followed for decades now. Now, similarly, in section 176 also, a change has been made in that the if in section 176, which used to be section 157 earlier, so 157 has been converted into section 176. In 176, a clause has been added. What this deals with the procedure of investigation. Now, what used to happen that there were statements which were recorded during investigation by the police officer, and thus now the amendment has been made that these statements can also be recorded by audio video mode. So it is like, I think this amendment, this new bill is trying to include technology within the procedure of criminal code, because now mobile phone is something, a video recorder is something which is available with every police officer. So use of mobile phones and video recording and audio recording would bring more sanctity to the proceedings. So this has been again added in this particular bill, that you would use the video recording to examine and record the statement. Now, after this, in section 164, there are minor amendments which are made. 164 is with regard to the statement before the judicial magistrate, but that change is only limited to the recording of that statement by audio video mode. So this is again a step in right direction, that magistrate, if like we all know, virtual court is the need of the hour. People, Supreme Court of India, from starting from CJI, is taking steps to make sure that the video conferencing and virtual hearing reaches to the level of magistrates. And in the third phase, which is undergoing, the a huge amount of budget has been allocated to ensure that the video conference and virtual hearing facilities are used by the trial courts. Infrastructure is being created in every court, and this is in the pipeline, that this is very important. And what in section 164, which is now section which will now become section 183 of the new criminal procedure code, is it would be that in cases of crimes against women, all statements recorded under this section should be preferably done by a female officer under her signatures. Another very important is this, that the magistrate, if the offense which has been charged is punishable with up to death, and you are recording statement in that matter, then that power is given to a fairly senior judicial magistrate, not to any magistrate in the district. That has to be done if the offense is punishable up to death. Then the statement has to be recorded by a judicial magistrate of a higher rank. So this is included in section 1, prior section 164, and the new section, section 183 of the CRPC. Now, after this, amendment is made, very important amendment in section 185, which I have dealt, is with regard to the video recording of the search which has to be conducted. Section 185 again records, which was section 165 in the previous code of criminal procedure, which is with regard to search by a police officer. In that, they have included a search conducted under this section shall be recorded through audio video recording, means preferably by a mobile phone. So this again is a very important change, as I have explained. The reasoning is this: it brings more fairness in the investigation, chances of false implication get reduced, and the deniability of the accused in court also reduced, because once you are seen on video that the particular article has been recovered from you or at your instance, the deniability becomes minimal. You can only say that it is not in accordance with law, section 65b certificate is not there, make all those technical objections. But the aspect that this particular thing or the fact has happened is reported on a video. So the chances of denial by an accused will also go down. So we have to, as a defense counsel, if the task is difficult for us, we have to come up with some new defense. Now, after this, I'm skipping this. There are some changes, but these are very minor changes. In section 190, 190 is the new section, which used to be section 170 of the previous CRPC, which is in force now. This talks about that once section 190, I'll just read it for your convenience, because if upon an investigation under this chapter, the officer in charge of a police station that there is sufficient evidence and reasonable ground as aforesaid, the such officer shall forward under custody judicial magistrate empowered to take cognizance. So 170 is filing of police report. So once a investigation is complete and the police officer has found that there is sufficient evidence, the police report is prepared and that is sent to the judicial magistrate. So what change has been done in this is that suppose the accused against whom the police report is filed and he is in custody, there is no requirement of presenting him physically before that court. He can be produced virtually if he is in judicial custody or if he is in custody of some other state. So, and what I'll tell you what practically happens. Suppose I am, we have to deal with the situation as it exists on ground. On ground, what happens that there are offenders who are involved in multiple crimes. Some in this state, some in other state, maybe some in Delhi, Bangalore, multiple states. So what this leads to a process where a lot of time and dates get wasted, because the requirement was that if a charge sheet is filed, then that person has to be called from Bangalore, produced before a Delhi court, and a charge sheet has to be filed before him in his presence. Now, the requirement is simple. If a person is in jail, maybe in jail of some other state, he can simply appear through virtual conference, charge sheet can be filed, and his attendance can be marked. So this will save at least 2 to 3 dates in every proceeding minimum. So this will contribute to lesser number of dates being given in a criminal trial. And in turn, this will reduce the time frame which we take. As of now, the average number of years for a criminal trial to conclude is 3.5 to 4 years. I think with all these initiatives which are included, it can drastically reduce to half. Maybe we can finish trial within 2 years, maybe in 1 year, if the procedure is followed in its letter and spirit. Now, after section 190, another amendment is with regard to investigation should be completed within a reasonable period of time. What section 167 of the previous code gave power to police to complete investigation in 60 days if the offense is punishable up to 10 years, and 90 days if the offense is punishable more than 10 years. So now what they have done, and what was happening in this scenario was that the only benefit was this, that once you do not complete your investigation in 60 days, the person has to be mandatorily released on bail. Similarly, in cases where the time period is 90 days, then the person has to be released on bail. But the police has endless number of time with them to complete their investigation. So what used to happen that there would be a case in the docket of the court, but the investigation is not complete. So what they have done, that the time period has been reduced to 90 days. That after completion of investigation, even when the matter is referred to the court, if you have to further investigate that matter, you can only do with the permission of the court, and that too within 90 days you have to conclude. Another very important aspect which has been added in this, that the copy of the charge sheet is also required to be given to the victim, and the progress of the investigation is also to be informed to her, him or her, whosoever is the victim. So previously, if there is a complaint filed by anyone, he will only get to know what has happened to that complaint once he gets the summons to appear as a witness. Before that, unless he is running after the police, he will not get any information. So people, I've seen, people getting surprised and sometimes even shocked that how come they have received summons for a complaint which they gave 3 years ago, because they would not even remember. I remember a friend of mine, he had an accident, and after 3 4 years he received a summon from the court to come and give evidence. He was not even, he was so surprised that वो 3 4 साल पहले I this happened. I don't even have any knowledge what has happened till date, how charge sheet was filed. So in order to cut out this kind of conduct, the legislature has included this provision that even the victim has to be updated about the investigation and the progress of investigation. This is done in section 193, clause 193, which was previous section 173 of the existing code of criminal procedure. Now, another aspect has been added is with regard to that once a police report is filed, a charge sheet is filed. Previously, the copy of the charge sheet was to be provided to the state, yani prosecution, and to the accused persons. Now, with this amendment, the requirement is that the copy of the charge sheet will also be given to the victim, so that the victim can also participate in the trial and conduct and assist in the trial. So this would enable the victims to effectively contest their cases. As of now, the situation is victims do not have a right to conduct the trial. They can only assist the public prosecutor in conducting the trial. So if I am victim of any offense and FIR is registered, it becomes a state case. So the state is in charge of the prosecution, and the state, through the public prosecutor, becomes the custodian of that case. So if I am a victim and I want to participate, I cannot do it independently. What I can do, I can only go and assist the prosecution with their permission. So if a public prosecutor of the court says, no, no, I don't need your assistance, I have no right. I can simply stand in the court and watch the proceeding. But now, because this amendment has been made where the copy of the police report, that is the charge sheet, has to be supplied to the victim also, it necessarily gives the victim the right to participate in the trial. And this is a very important thing which has been done, because in our country, prosecution, and I have worked for prosecuting officers. I am retained by them. I work from them. I have filed multiple PILs for them to increase their salary, increase their facilities, because they are not provided adequate infrastructure. But I also know the manner in which the prosecution is conducted in this country is not even average, it's below average. And the comparison between a defense counsel and a prosecution can never be done. A defense counsel comes with a team of lawyers to defend the accused, with the research, everything. A prosecutor of the court has to deal with 50 cases a day. So he does not have that number of resources at his end to be able to give give that kind of effective representation. So this, I think, is a step in the right direction. And now, another very important thing which has been done in this section is this, that they have limited the time frame of the police to further investigate the matter. Because what used to happen is this, that police will file a charge sheet and say we are further investigating the matter, and we will file supplementary charge sheet or supplementary police report. So no time frame was given. Now, subsection of this particular 193 proviso to section 9 says that you cannot investigate beyond 90 days even with the permission of the court. So there has to be some closure so that court can start the trial. Because if the investigation is pending, then the accused would come and say, "अरे अभी तो investigation चल रहा, आप charge क्यों frame कर रहे हो मेरे खिलाफ?" That has to be avoided, because once the charge sheet is filed, that is considered as a pending case. Because there There is no fault of the court. The court is sitting there to conduct the trial, but the investigation is pending. So now this proviso has been added, and because this is very important, therefore I would read this: provided the further investigation during the trial may be permitted with the permission of the court trying the case, and the same shall be completed within a period of 90 days, and which may extend with the permission of court. So 90 days is the time which has been given by the legislature. If the appropriate court thinks that okay, some more time has to be given, that is within the discretion of the court, that you can give that particular additional time beyond 90 days. So this gives some superintendence to the court over the investigating officer, that complete your investigation in time so that we can proceed with the trial. Now, similarly, after this, I'm going to skip, because we are short on time. I'm going to skip few minor amendments which have been included, but I'll deal with few very important amendments which have the tendency to completely change the procedure which we follow in court. So I would request to see clause, just a minute, because I'm skipping multiple sections. So just a minute. Another important section which has been amended, and this is a section which is not added, it is an amendment to the existing section, is to section 200 of the existing CRPC. So section 200 of existing CRPC is that when you give a complaint to a magistrate under section 190, the examination of the complainant and the witnesses is to be done and cognizance is taken. So the concept which we follow as of now is that magistrate will take cognizance, examine the complainant and two or one witnesses, whichever witnesses is produced, and after recording that statement, if he is satisfied that offense is made out, he would issue summons under section 204 of CRPC. Summons process will be issued. Now, this amendment, what it attempts to bring in is this, that even at the stage of 200, that is prior to issuance of summons, the accused, the prospective accused, has the right to be heard. As of now, the code and the law of the land in the nature of the judgments of Supreme Court and High Court does not permit a right of audience to the accused before he has been summoned under section 204. But now, because even if cognizance is taken, this becomes a pending case against you. It can show in the system. So therefore, you are given a right to participate and object to that proceeding. So this is very important amendment which has been made. And though this is not an insertion of new section, this is an amendment to the existing section, but it has a far-reaching consequence in the conduct of proceedings in the court. Therefore, it was very important for me to refer to this. Another very important change which is made is the concept of sanction. Under the existing CRPC section 197, the sanction has to be taken. So that section has been converted and changed to section 218 of this bill. In that section, a deemed provision, a provision with regard to the deemed sanction has been added. What is the procedure? That if I am a public servant or there is a statute which mandates that there has to be a sanction to prosecute me or any third person, if there is a special law that you have to take sanction. Now, the delay would be caused because the sanctioning authority would take maybe years in giving that sanction. And in 2G case in the Supreme Court, Justice Ganguly had given a judgment saying that if you don't give sanction within 120 days, then the sanction would be deemed to be given. So that judgment is given effect by including this proviso in section 218, which says, provided further that such government shall take decision within period of 120 days from the date of the receipt of the request for sanction, and in case it fails to do so, the sanction shall be deemed to have been accorded by such government. So once a government or the sanctioning authority has received the request for sanction and they do not grant sanction within 120 days or do not reject the sanction within 120 days, then it would be deemed that the sanction has been given and the court can proceed accordingly in that matter. This is very important because public servants were misusing this provision to delay the sanction and thereafter challenge these proceedings on the ground of delay. So they would be having two benefits. Firstly, they will delay, and then they will take benefit out of that delay. So this has been attempted to be done away with. After this, I would request and I would deal with. I have dealt with Section 200 uh, process to the accused. Then this section has been converted to Section 223 of the new bill. And after this, I would come and I will quickly skip that under this provision, under this new bill, service of summons can be done electronically only. So it is like you can send a summon with the seal of the court and you can electronically transmit that summon and that would be deemed to be a service of summon. There is no longer mandatory requirement of serving physical summons on the accused. So this is very important in keeping in line with the technology. And as I have mentioned earlier, under section 2030 also, which is 207 in the previous CRPC, the victim has also been given right to be given the copy of the charge sheet and the documents. So the scheme of the act is now that victim is equal participant in the trial. So this is very important considering the nature of the offenses. And another very important aspect is with regard to section 209 of the old CRPC, which deals with committal. So what happens? A charge sheet after investigation is filed before the court of magistrate. A magistrate, if founds that the offense which is arrayed in the charge sheet or for which it is punishable is triable by the court of session, then he would commit that case to the court of session. And there was no timeline to do that. Now, in this section, under section 232 of the new bill, a proviso has been added that within 120 days, the committal proceedings have to be concluded. And it can only be extended to 180 days for the reasons to be recorded in writing. So you cannot keep a matter pending at the stage of committal for more than 6 months, and even that can be done for a exceptional reasons to be recorded in writing. So this, in my view, is also a very important aspect which has been added in this new CRPC. After this, we would come and we would deal with, because after this there are not multiple changes which are made, but now what happens at the stage of trial? Now we have come, documents have been supplied, accused has been summoned, charge sheet has been given to them. Now what will happen at the stage of charge? So at the stage of trial, in section 250, which was previously section 227, dealing with the discharge of an accused. Similarly, in cases of magistrate also, the application seeking discharge has to be preferred within 60 days of the date of framing of charge. So it is not that endless period of time is given to you that after 2 years of trial, you suddenly wake up and file an application seeking discharge. That has been done away with. So all this, we can see the intent is, firstly, the intent is to make it equal. You bring the victim also within the domain of a natural party in the trial. You try to use the technology. You try to reduce the number of time taken to conduct investigation and trial, and you try to bring fairness in the process of investigation and trial. So these are the four major heads, I think, for which these amendments are made. After this, and this is a amendment which has been made to section 246 of the existing CRPC, and the new provision is section 269. What this does, this gives the power to the court to close the evidence of the prosecution if the witnesses are not appearing. Now, we have seen on daily basis, there would be cases where the witnesses of the prosecutions are not appearing. multiple opportunities are given to them, they will not appear. But the magistrate or the court does not have a power to say that we will not examine this witness unless the public prosecutor says, I am dropping this particular witness from my list of witnesses. So a consent has to come from the public prosecutor saying that, okay, I am dropping this witness. But now, with this amendment to section 269, a new subclause is inserted by which, if the judge feels that after giving all the reasonable opportunities to the prosecution, the witness is not coming, the judge can pass an order dropping that witness and proceeding in the case further. If it leads to acquittal, okay. If doesn't, that matter has to continue. But it is not within the domain of prosecution to give consent, because magistrate was feeling powerless. And this we would see that I have dealt with 2 3 cases where the accused has been appearing in court for last 2 to 3 years, but there is no witness who's from the part of the prosecution, and this is causing a lot of delay and harassment to the accused, because he has to present himself on every date. He comes, maybe sometimes they have to travel from different states, maybe he has to take off from his work, but the witness is not there. So eventually all this leads to the harassment of the accused also. So this has attempted to do away with this particular problem also. After this, I'll just run through this because
Whoever is using this whiteboard, please stop using it as it is creating disturbance.
I'm sorry. Ah, so what it another very a small change which has been done, a small provision has been added, that if a case is triable as a warrant trial and the punishment is up to 3 years, then the magistrate has been given power to convert that warrant trial into a summary trial and try it. So this also is done to save time on the criminal trials and to save the time of the court. This was not existing before, that if a case is there, it is, if the punishment is 3 years and the case is triable as a warrant trial, the court had no jurisdiction or discretion to convert it into a summary trial. So now, even up to 3 years, they can convert it and have it tried as a summary trial. The entire analogy and the concept of summary trial is something which has to be explained. But it is, summary trial is much faster. And after this, there are minor changes made to the concept of plea bargaining. Plea bargaining, what they have done, that if you are a first time offender and you uh, adopt the process of plea bargaining, you can be given minimum sentence up to the 1/3 of the minimum sentence. So if the minimum sentence provided under that offense is 1 year, so the court has discretion to give you 1/3 of 1 year also. Whereas the law is that a court has no discretion to give sentence lesser than the minimum sentence provided for the offense. But for the purposes of plea bargaining and saving the time of the court, what they have done, if there is a minimum sentence provided, the court has discretion to give you 1/3 of that sentence, with only one caveat, that you should be a first time offender. There should be no previous conviction against you. So this is a good amendment which has been done. And after this, these are all minor amendments, so I'm skipping them, 398 and others. Another of same thing, that even accused for recording of a statement under section 313, which used to happen earlier, can also be done under the electronic way. It is not necessary for accused to be produced from custody or to appear in the court. His statement can be recorded by electronic means also. After this amendment, and very important amendment, a new provision which is added, is by way of section 336, which says that suppose there is a public servant who has given an evidence, there is an expert who has given some report. So in the absence of the person who is author of that report or who has manufactured or created that document, you cannot proceed. What used to happen, I am, for example, I prepared a report as a scientist in the CFSL department, Forensic Science Department. Subsequently, I retire, I shift to other country, or the person is dead. What used to happen, that report would not be read into evidence till the time that expert comes into the witness box and substantiates that report, because the accused had a right to cross examine. Now with this amendment to this new section 336, the provision has been made that the successor in office, the successor in that FSL office, can come and give evidence in that regard. This is somewhat problematic if for the purposes, because he may not have the express knowledge of how that report was prepared. So he is not, he does not have personal knowledge. In my view, this is something, this is a problematic amendment. This needs some consideration, because this is going to lead to a scenario which is, there are chances of it being misused. The right evidence may not come on record, but this amendment has been done. My reservations are there, but the parliament has deemed it fit. If it comes to being enacted as a law, it can be challenged, and I'm sure it would be challenged by interested people. Now, after this, a very important amendment, and I think very, very important amendment. In a criminal trial, the accused cannot seek more than two adjournments. Previously, there was this provision, but discretion was with the judge in section 309 to give number of adjournments. But now the provision is very clear, where the circumstances are beyond the control of a party, not more than two adjournments may be granted by the court after hearing the objections of the other party and for the reasons recorded in writing. So even for the circumstances which are beyond the control of a party, you cannot take more than two adjournments. This is going to cut down a lot of time when the trial, in the time when the trial happens. And this is very important amendment, subject to being rightly implemented in code of law. It should not be that this provision only remains on statute books. It should be implemented, because high time we have to speed up with our criminal justice system. It cannot be that trials are pending for 5 to 7, 8 years. So we have to cut down on the number of years taken for a criminal trial. Another, and this is with regard to a new provision which has been added. This is with regard to conducting a trial of an accused in his absence, in absentia. Now, we have seen situation that the accused would run away from the country. He would go to some country which has no treaty with our country. He will become a fugitive. But all the law machinery or the law enforcing agencies could have done was to declare him a proclaimed offender. Not more than that. He would not be declared as a convict because he has not faced any trial. But now, a provision in the nature of section 356, clause 356 of the new bill is added, where the person who has been declared a proclaimed offender, he can be tried in his absence and he can be convicted also. And that sentence would be binding. He cannot appeal against that sentence unless he appears before the appellate court. So take this example. A particular accused has run away, declared proclaimed offender. Court proceeds with the trial, and proceed with the trial is very important because there is a safeguard. The safeguard is, it is not only the police report that he is a proclaimed offender, even the summons would be sent to his relative. And even after that he does not appear, then he will be declared a proclaimed offender by the court, and the trial will start in absentia against him. So in that trial, if evidence is led against him and he is found guilty by the court, he would be convicted. But there is a right to appeal given to him, but that right to appeal can only be used by him if he appears personally before the appellate court. He cannot be sitting in third country and say, you cannot convict me. So today, let's take example of Bombay bomb blast. Dawood Ibrahim till today is not a convicted person. He is a proclaimed offender. So if trials are held under section 356 now, even the offenses where the accused has not participated, he can be convicted and can be treated as a convict. And what happens when he is treated as a convict? All those international treaties come into force, and the person has to be sent back to the country to undergo sentence, or he has to be taken into custody where he is residing. So this is a very important amendment which has been done. And again, this is not something which we have discovered. This is again in the light of United Nations conventions, in the light of treaties which we have done. After this, there are minor amendments which are made to the section 320, which deals with the compounding of offenses. New section is section 359. And after that, amendments are effected. Major amendment has been done to withdrawal. And this is very like most of these are important, but this is very important in this situation which we are living as of now. We all have noted that what will happen, there are prosecutions launched against these politicians who are in, who are contesting in elections and all those things. So when these politicians come to power, they would use that state machinery to withdraw that prosecution against them, because a state, as I have mentioned earlier, is the custodian of the prosecution. So if a state says that I am going to withdraw prosecution against this particular gentleman, the court had no liberty of saying no, no, we will continue. The Supreme Court had on several occasions said that this is such a wrong practice. Even it has been challenged. There are still multiple, I think, PILs pending in the Supreme Court dealing with this aspect. But now what has been done is the victim is given a right. The new provision is 360. A proviso has been added. The section has not been complete, new section has not been added. Only a proviso is added saying, provided further, no court shall allow such withdrawal without giving an opportunity of being heard to the victim in the case. So at least the malafide and the motivated state is out of the question, because state is going to do what the masters are saying. But at least victim can participate and oppose it, and court can have some discretion of allowing or refusing it. Previously it was within the domain of the executive, that is the state, to withdraw that prosecution. Now that has been done away with. After this, there's one more major amendment which I would like to deal with as far as CRPC is concerned. And I'm taking most of the time on CRPC because on IPC there are 7 to 8 changes which are in conformity with CRPC only, and in evidence law there are not many changes. So we can quickly skip through them, but CRPC was very important. Therefore, I have given maximum period of time to this code. Small amendment but important, that once a judgment has been pronounced, the soft copy can also be provided to the accused and uploaded on the website. That would be sufficient in compliance. There is no mandatory requirement of giving hard copy to the accused. And similarly, that copy is also to be given to the victim free of cost. Previously, victim had no right to obtain such copy. They can go and apply for certify, which would take some time, and victim will again be. Very important. Supreme Court, I think 10-15 years ago, said witness protection should be there. In our country, and in fact in most of the countries, people do not come forward because there is no witness protection program in our country. Now, there is a judgment by the Supreme Court which says that there should be a witness protection program. But this new CRPC, the bill includes a provision in the bill which says that this is the obligation of state government to have a witness protection program in the state. Section 398. It is a new provision added in the code which says witness protection scheme. Every state government shall prepare and notify a witness protection scheme for the state with a view to ensure the protection of the witnesses. This is very important because what we have seen, and mostly when you are dealing on the prosecution side, is this: the witnesses do not want to come forward. You will see charge sheets which are filed. There would be one or two public witnesses who are the victims or who are relative of the victim, but you will not find general public coming forward and deposing. So I think this witness protection scheme can change this situation, but it will take some time because a scheme has to be implemented on ground. So this may take some time, but at least now there is a statutory obligation on the state government under the code to have a witness protection scheme. And one last, I'll just quickly go through that. Witness protection has been done. Another last provision is with regard to the mercy petition. We all know that the president and the governor have the power to entertain mercy petitions. But what was happening was this, that the mercy petitions were not getting decided for years and years. And many get- convicts have got benefit of that, starting from Mr. Devinder Pal Singh Bullar, who is a Punjab-based terrorist. He's convicted. He was sentenced to death, but he got benefit of the delay of mercy petition in the adjudication of mercy petition, and his death sentence was converted to life sentence. So there are multiple of such cases where the convicts have taken benefit of delay caused by state to deal with the mercy petitions. They invoke their Article 21 saying that you are firstly keeping me behind the bars for 10 to 14 years. And after 14 years, you are hanging me. So it's like I am serving the life sentence and then you are punishing me with death. So Supreme Court has rightly taken a view that yes, in these circumstances, it is the Article 21 of that person gets violated, and therefore you cannot be sentenced to that. Your sentence of death cannot be executed. To do away with this kind of situation, the section 473 has been added into new bill, where it says that the state would inform that like if appeal has been dismissed, SLP has been dismissed, or the time period to file SLP has been dismissed, which is 90 days. Then the state would inform the victim, the accused, and his family that the time has elapsed. Now you have a of uh, period is that you have particular period to prefer the mercy petition in accordance with law. So 60 days has been given. So suppose I am a convict, I have awarded death sentence. Death sentence has been upheld by the High Court, and maybe I have not preferred a appeal in the Supreme Court. Time limit to prefer an appeal in Supreme Court is 90 days. So unless I have preferred an appeal, I have to wait for the outcome of the appeal. Suppose in cases where appeal is not preferred, then after 90 days, because the limitation period is 90 days, the state government would inform that your time to file a mercy petition is getting over. If you don't file a mercy petition within this particular time, the sentence of death may be executed. So this is something which gives a opportunity to the convict to take recourse to the law and later on not take advantage of delay. So this, I think, is going to help in deciding these kind of matters. And in any case, in our country, death is rarest of rare. In most of the cases, death punishment would not be granted. The Supreme Court is very liberal, starting from Bachchan Singh's judgment till Mr. Bullar's judgment. It is continuously being held that, sorry, death sentence, rarest of rare cases. So this, I think, as far as the Code of Criminal Procedure is concerned, this is the major changes which are effected in the CRPC. And another very important thing which has been done, and I have saved it for the last, was this: the changes with regard to the use of words. I will show you some words which have attempted to bring our system in conformity with the current times. Multiple words which had that colonial legacy have been tried to do away with. Number one, the word barrister, pleader, attorney, or vakil have been removed from all three acts. It has been replaced by word advocate, because we no longer have barrister system, we don't have pleader system, we don't have attorney system. It's only a lawyer or an advocate who represents. So an advocate word is the only word. At present, words like barrister were there. The word lunatic and a person of unsound mind has been removed from the acts. It has been replaced with person with mental illness. I think this is very important. Replacing the Indian Lunacy Act has been replaced with the Mental Healthcare Act of 2017. The word asylum, very, I think it's a very demeaning word to say, you're going to mental asylum. The word asylum has been replaced with public mental health establishment. So these are some changes which, though may only look like a word has been replaced, but the entire psyche behind these amendment is such that you want to provide a respectful address to these kind of people. You just don't want to address a person as lunatic. Okay, you may have some mental disease. You can be called as a person with some kind of disease. Not to refer someone as he's a lunatic, he's some kind of that. These words, when are used in our criminal justice system, they add insult to injury. So this is the amendment which are effected in CRPC. Now I'll quickly start with the amendments in the Indian Penal Code. As I had explained, the amendments in the Indian Penal Code are minimal. They are not to that great extent. Now, the Indian Penal Code, as I have said, that in the existing Indian Penal Code, there are around 511 sections. I'll just have a class of. So now, in the current IPC, which is of 1860, we have around 511 sections. They are replaced. Now there are only 356 sections. 175 sections have been repealed or amended, 8 have been added, and 22 sections have been repealed. Now, what is the key change which has been done in IPC? Offense of sedition under section 124, it is subject matter of lot of debate. Even in the Supreme Court, a petition is pending wherein the Supreme Court has stayed the further implementation of sedition laws, that you cannot arrest a person under sedition. So the government has repealed that particular provision, but now has introduced a new offense. The offense is not in the nature of sedition, but it is in the nature of a offense in which the penalty is for exciting or attempting to excite secession, armed rebellion, subservice activities, encouraging the feeling of separatist activities, endangering the sovereignty of unity or the unity and the integrity of India. These are the 4 brackets within which the offense is tend to be committed. It is no longer sedition, because sedition has that colonial legacy that, okay, you are doing sedition against the queen. That is no longer there. So these 4 situations, I'll repeat: exciting or attempting to excite secession, armed rebellion, subversive activities, encouraging the feeling of separatist activities, endangering the sovereignty, unity, and the integrity of India. And all these acts can be done by signs, electronic communication, use of financial means. So these are the three ways. It is not only that you have to do some physical act, even by signs, by use of literature, you can do these kind of offenses, and the prosecution can be launched. But, and I think the change which I'm going to mention with regard to the punishment, it is a right change because the punishment has been reduced. The concept of sedition has been taken away, life imprisonment taken away. The only is if you are going to do something against the interest of country, then you can be punished up to 7 years and or in maximum up to life in certain cases. It is not mandatory. Before the mandate, the sentence was life. So this was a very, I think, what should I say, a very strict provision. Though the Supreme Court had watered down the impact of that provision, multiple judgments starting from 1960s to Mr. Vinod Sharma's Vinod Dua's judgment of 2021, authored by Justice Lalit. I'll personally advise each and every one of you to please go through that judgment. That is a piece of literature written by Justice Lalit. How it deals with the concept of sedition, the concept of armed rebellion, the concept of using physical means, and the concept of freedom to disagree with the government and to protest. That is such a brilliantly worded judgment. It should be read by every law student and a lawyer. Maybe you are not dealing with sedition cases, but you should understand the concept of democracy and how a right to protest is there. Similarly, one very important change has been done in the new IPC is, just imagine this situation in our country. Our country is dealing with the menace of terrorism for last 20 to 25 years. 89, 90, 93, 2004, Bombay, everywhere, multiple terrorist activities. Hundreds and hundreds of people have been killed. But sadly, till today, we do not have a statute which defines the definition of terrorism. And even worldwide also, the United Nations, despite its best efforts, is not able to come to a consensus amongst the countries to have a definition of terrorism. It is for the first time that with the Bharatiya Nyaya Sanhita bill, the definition of terrorism is included. The definition of terrorism under this new bill is, and I will read, an act that intends to threaten the unity, integrity, and the security of the country, to intimidate the general public, or to disturb public order. Terrorist acts include using firearms, bombs, hazardous substances, biological or chemical, to cause death, danger to life, or to spread message of fear, destroying property, disrupting essential services, and activities included in the treaties like second schedule to the Unlawful Activities Prevention Act of 1967, which we all know as UAPA. Such unlawful seizure of aircraft taking hostages. Very important. Imagine we are a country which has seen the hijack of Air India, which was taken to Kandahar. Even the hijacking of aircraft was not included as a terrorist activity in the statute. It is only now, and when this bill comes into the force, the such act would be considered as a terrorist activity. So when we hear terrorism on our television and in public discourse, it is only limited to that. In the word, when a charge is framed or when a judgment is passed, there is no reference to the word terrorist activity or terrorism, because there is no definition in the statute book. So now this has been added, and punishment for attempting or committing terrorism includes death or life imprisonment, where the offense has resulted in death of any person, imprisonment of term between 5 years and in life in other cases, and further, an offender will also be liable to a fine of at least 5 lakh rupees. So this is a provision which has been added with regard to the terrorist activities. Similarly, definition of organized crime is included. Another definition is included with regard to the petty organized crime, and another important amendment, which is like this is being discussed in on public platforms on daily basis, is with regard to the mob lynching activity taking place. So that has been dealt with, and that has been dealt in a manner where it has been defined in the bill as murder by a group of person on the ground of caste or race, not religion, contrary to the perception which is being developed in in the public discourse, that it is also on the ground of religion. Sorry, the bill does not uses the word religion, it is only caste or race. The bill specifies separate penalty for murder committed by more than 5 people on the grounds caste, race, sex, place of birth, language, or personal belief. So this is made punishable from 7 years to life or to death, and it is also applicable to the repeat offender. So this is also there. Another very important amendment, which is in conformity with Justice J.S. Verma's recommendation done after the Nirbhaya gang rape case, is death penalty for gang rape of a minor. See, Justice J.S. Verma committee recommended that there should not be death penalty for rape. But for heinous rapes, including gang rape and rapes of minors, it was suggested that there should be death penalty. So now it allows this particular amendment. It allows death penalty for gang rape of a woman below 12 years of age, and it also allows death penalty for a gang rape of a woman below 18 years. So any minor, if subjected to gang rape, then the punishment is up to death. So this is a very, I think, a right amendment. Then comes uh, the sexual intercourse by using deceitful means. So this is termed by various people as you know illegal activity which is going on. Kerala High Court has recorded it. Bombay has there some judgments on this point, that you deceive someone with regard to your identity, with regard to your belief, and then indulge in a relationship. So that has also been termed as a sexual intercourse by deceitful means, and this has been made punishable up to 10 years by the court. And in some cases, what is happening is this, that uh, people, there are attempts being made that this issue is only with regard to some religion or a deceit which is done on the basis of uh, hiding your religion or not telling your correct reason. But no, the act is very clear that if you deceive someone with regard to your identity, promise of marriage without intending to fulfill it, because the word is with promise to marriage without intending to fulfill it. So there is a burden on the prosecution that you have to show that, okay, there was promise to marriage, but it was coupled with no intention to get married. And that promise was only made to have that sexual intercourse. Because we have seen uh, the rape cases, multiple rape cases are filed on the ground of promises of marriage, but these are not, I will not say misused, but they are not presented in right manner. Because what happens even in cases of live-in relationships, when you are living with person for last 2 years, 1 year, when the relationship breaks away, there are instances where rape cases are filed. So Supreme Court, now there are series of judgment available on this point, that in these circumstances it cannot be said that it is there was a false promise or false premise to marriage, because you were aware, you were in the living relationship with that person. So now to say that because the person has not married you, that doesn't attract that policy or the offense of rape by deceit, by hiding your by promise of marriage. Now this is the major changes which have been done in IPC. Most of the offenses have been retained. The only offenses with regard to the offenses by public servants have been done away with, because they have been included in CRPC, as we have seen. Now, with regard to the Indian Evidence Act, the new is Bharatiya Sakshya Bill. As I had explained, it includes 170 sections now, instead of 167 as it existed. 23 sections have been changed, one section has been added, and five sections have been permanently repealed by the bill. Now, what has happened in this Evidence Act new, the Bharatiya Sakshya bill, is this: the admissibility of digital record and electronic record is made admissible as an evidence. So it also expands the definition of electronic record to include the communication devices also. Previously, the electronic devices only included the computer, the laptop, and other kind of electronic devices, but not the communication devices. So now even a mobile phone, a iPad or a tab would be considered as a electronic device. Laptop would also be considered. And so any material or evidence stored on that would be taken as an evidence and would be admissible in trial. Similarly, oral evidence has been given on a higher footing. Previously, oral evidence was not that mandatory. There was some, it was not believed in that extent unless there is something in writing. Secondary evidence. Secondary evidence is something, I'll just give you a brief information about secondary. There are two types of evidence: primary or secondary. Example: there is a document signed by me in original. If I produce that original document on record, it becomes primary piece of evidence. But if I do not have the original with me and I have a photocopy, that becomes a secondary piece of evidence, not having the same level of correctness or authenticity as an original would have. So the best evidence is primary evidence under the current law, which is prevalent. But under this new amendment, even the secondary evidence in the absence of primary evidence is attempted to be given a larger meaning, a larger weightage. I'll say the bill expands the scope of secondary evidence to include oral and written admissions, the testimony of a person of a document skilled in the examination of document. So, for example, if I have orally stated somewhere and there is no evidence in writing, so even that can be admitted, and the evidence of an expert of writing, who we called as these scientific examiners, even they can come and prove that. So that would not be taken as secondary evidence, and it will have a greater bearing in the trials. Now, production of documents is also, because previously all documents had to be physically produced. Now, and suppose if the party is not producing those documents, then the court can only took adverse inference against that person. Suppose the other party is alleging that I am in possession of a material evidence, a document which is going to favor him. So obviously, I'm not going to produce it on record. Even if he files an application and obtains a direction from the court will direct me to produce that evidence. But if I don't do it, the provision of executing that order was not there. The only requirement was, and upheld up to the level of Supreme Court, was this, that you can only take adverse inference. Acha, this person has not produced it. Okay, so he must be hiding it for some reason which is adverse to him. So that adverse inference was the only thing which can be done by the court. But now it has to be mandatorily produced, regardless of any objection. So now the statute contains a mandatory requirement enforceable by the court. So suppose now the person is not producing the evidence, the court can pass an order directing it and then implementing that order by executing, maybe by attaching, maybe by asking the police to seize that document. What steps can be taken by the court? Previously, these steps were not within the domain of the court. Similarly, joint trials, very important aspect has been done again in order to reduce the time for trial, because what used to happen that for particular offenses, multiple accused were there and there would be different trials for every accused. So now what they have done, that they can be a joint trial, and if a confession has been made in one of the trial, it can be used and proved in other trial also. So there was no requirement now to have multiple trials for same set of offense where the accused persons are different. So, see, there are offenses which are done in transaction also, and these are very complicated offenses. So, for that offenses, it was very difficult to have different trials, and all these trials were pending at different times, resulting in delay of proceedings. So, this has been done away with, and a concept of joint trial has been introduced. So, I think these are the major changes which have been effected. And as far as I have gone seen these changes, they are majorly on the aspect of providing a better opportunity to have a fair trial and fair investigation. But let's see how these provisions get implemented. And in my view, there are only problems with regard to two or three sections in which some excessive power has been given to the authorities. I think that has to be looked into, and otherwise, it's a reasonable exercise done by the legislature, and this will bring us to the international standards, subject to infrastructure getting available. It's very easy for us to say to have everything recorded it in electronic mode, but if the trial court does not have internet facility or the speed is low, it doesn't serve the purpose. So everything is there on paper. Let's see how it gets implemented, and this is something which I had to discuss with you. And if any questions are there, I think the moderator would ask.
So, sir,
And
that
I'm
was
sorry I've taken a
certainly
little extra time because there was too much to be discussed.
no worries, sir. It was a very detailed and explanatory session, sir. Participants, you all can share the questions in the chat box or raise your hand and I'll allow you to unmute yourself. I suppose there are no questions. Last 1 to 2 minutes, participants. Please feel free to unmute yourself. The feature is now available to you. Okay, there's one question, sir. What is the difference between clause 172 of the new criminal procedure bill and preventive detention?
See, preventive detention is done under a statute, and it is for a longer period, minimum for 90 days, unless it is quashed by the Constitutional Court. Whereas the 172 only provides for a detention for a period of some transaction. As I explained, let's suppose there is some protest going on, or some group of yatra or religious procession is going on, and a police officer feels that this particular group of people may be disturbed by this other group of people. So they may detain these any group of people or a person for that particular period of time till that procession passes. Like we have seen on television that if there is a protest, the police will detain those protesters, take them to take them in some buses or maybe in police jeeps and drop them to some different location. So now at least they don't have to do that, because that adds to most of the resources get problem. But now what they can do, they can detain them and then subsequently they can be released without any case. It is not that FIR has to be registered against them. It is only detention, not to be not to affect any of their credibility or the record in future.
Next question is, by when would these changes, if assented to by the president, be applicable to Indian courts? And would it be difficult for practicing lawyers to relearn the new laws?
uh, for a lawyer, I can tell you from my experience, even till today we have to read every provision. It's not that if you have read something in law school and while you are practicing you will not read it. It has to be read over and over again, and each time you will read it you will find something new in this in the laws. So yes, it has to be redone. There would be some time to taken to adjust, and I think the real difficulty will come when it has to be implemented in courts. All these provisions for the staff, for the stenos to take down the correct dictation and everything. So it will take time, but we have to see the larger picture, that it is something which had to be done. Because imagine a nation where definition of terrorism does not exist. We cannot take evidence in electronic modes. We cannot serve summons in electronic mode. So we have to come to terms with the current technological advancements and the as it may be political, but yes, a legacy of colonial past which uses words like lunatic or person of unsound mind had to be done away with.
There's a similar question that for the law students who are in their fourth or fifth year who are currently studying these laws, so what should they do? Should they keep reading the current laws till the new ones are passed, or how should they? What strategy can they adopt?
I Let me tell you, see, it is not a, what should I say? It's not a complete new act. Most of the old provisions are there. Only as I have pointed out, in CRPC, only 9 new sections have been added. In IPC, 8 sections have been added. And in Evidence Act, 1 section has been added. So, can you, and it would not be that difficult to understand that sections are there. It is only renumbering and some minor additions. So, it is not that whatever my commentaries are there. I have these IPC, CRPC lying at my back, but they don't become redundant. They will be still be used. Similarly, your law books and whatever you have learned till today will be used. It is not a new system that has been brought in. So no need to worry on that part. In fact, if that would be, I would be more worried.
Sir, can you please name the case for sedition once again?
I'm sorry. It was Vinod Dua, that famous journalist. Vinod Dua's
Mm.
case on sedition, judgment given by Justice Lalit recently, 2021. And I'll also provide you the citation. And in the meantime, we can go to the other question.
All
I'll
right,
give
so
you the
sir, all right. Uh, there is one question for such detention. The time may extend till what's the maximum time?
it has to be less than 24 hours, because if you are detaining someone more than 24 hours, you need authorization from the magistrate. So, by necessary implication, it has to be less than 24 hours. But the language which has been employed in that section is for transaction or passes by. I'll just read that language again. So, language makes it very clear that it has to be for a very short duration of time. It cannot even be for 10 hours, in my view, because that will be illegal detention. So Vinod Dua's judgment is Vinod Dua versus Union of India, criminal writ petition criminal 154 of 2022, Justice UU Lalit's judgment, and judgment is of date 3rd June 2021.
Sir, there is one more question. After the implementation of new codes, what will happen to the cases registered on the basis of earlier codes? Will it not increase the burden on advocates as we have to mug up both the acts for both kinds of cases?
Firstly, no advocate mugs up any of the provision. It has to be read, understood, and dealt with. Secondly, when this provision or this amendment will be implemented, they will be prospective in nature, not retrospective. So whatever offenses have happened. Even till today, if an offense is happening even today, that will be dealt with the existing IPC, CRPC. So it will be for the fresh cases that will come, not for the earlier cases.
Sir, any book suggestions that you have for aspiring criminal lawyers with respect to three IPC, CRPC, and Indian Evidence Act?
Sohoni on criminal law, CRPC, very detailed commentary, 5-6 volumes. It's there on evidence. If you're a law student, please read Murphy on evidence. If you're a law student, Murphy on evidence. And for IPC, I think Ratan Lal would be good. It can be good for a law student and for a lawyer also. So if you are in your fourth year, final year, start with Ratan Lal. Good book, gives you background of the act, gives you the intent of the offense, and also gives you relevant judgment on the point.
Sir, can you please explain 356 clause of the IPC once again?
356 clause, which was this IPC. Can you explain? Can this person tell me exactly what? Can you repeat this thing?
356 of IPC.
56 of IPC. CRP, maybe of CRPC, IPC, so we have not dealt.
Yeah, I think that's some difficulty in the. I'll move to the next one. Till then, Nilima, please clarify your question once again. It will be really helpful for the speaker. So another question is, was it necessary to reshuffle the sections in which no changes were done? It becomes difficult to first unlearn and then again learn section number for PCSJ students.
See why it was. I will not say it was mandatory to be done, but I think it is done for a reason, because to bring all these sections into sequence, because the amendments which have been done or the new sections have been added would have, you know, given more confusion to all of us if these were not renumbered. Because then where do you bring those sections? You cannot have 5 with 12, 5, 13, 5, 14, because then it will be a completely different chapter. So it had to be, see, our IPC, CRPC is divided into all chapters, starting from definition, offenses, all those things, henceforth. So I think the intent was to avoid confusion. But yes, for some point of time, it is going to be a little difficult for all of us to deal with it. But as I have said, that I think this was the right time, because there were too many amendments. If you would read, like I'll give you an example. If you would read IPC and CRPC, you have to see different so many amendments in the act. But now with this comprehensive amendment, at least for next many years, we can be sure that okay, nothing major is going to change. So see what happened. What is the current situation? The current situation is such: 10 people have committed some offense, and I'll give you now example. Let's take example of maybe Bombay bomb blast, because everyone is aware about it. So in Bombay bomb blast, there are multiple accused who have been declared proclaimed offender. Let's Out of them, number one is Mr. Dawood Ibrahim. So Dawood Ibrahim till today is not convicted by any court. He remains a proclaimed offender. But all the other accused who have faced trial have been either convicted, discharged, acquitted, and their sentences have been upheld even up to the Supreme Court. So suppose if tomorrow Dawood Ibrahim is arrested and brought back to the country, then a trial has to be redone against him to convict him or prosecute him for Bombay blast cases. But now with this clause 356, a provision is made that once a person is declared as a proclaimed offender, charges matter is sent to court after completion of investigation. He is summoned, he does not appear. He is again summoned, he does not appear. Warrants are issued against him, non-bailable warrants are issued against him. The relative, the first hand relative, not some dur ka rishtedar, some first hand relatives are served. That case is pending against him. Charges are framed against him. And even after that, he does not appear. Then the court and the prosecution can continue the case in his absence. And if they come to a conclusion that yes, there is sufficient evidence against him, he can be convicted and sentence can be given to him. So this is a trial in the absence of the offender. Another very important aspect, as I had mentioned, it also includes that if Mr. Dawood Ibrahim is convicted in his absentia, then he has to appeal, or if he wants to appeal, he can only appeal once he appears before the appellate court. It cannot be he's sitting in XYZ country and he's appealing and using the mechanism as is being done by Mr. Malia. We have seen that he's not appearing in any of the Indian court, but he's sitting in London and using the criminal justice system and the court system even up to the level of Supreme Court. So this is being attempted to be done away with.
Okay, sir, can you please explain clause 356 of CRPC? I think we've just covered it. There was one more. Clause 360 of CRPC.
Achha, withdrawal of prosecution. Only one change. It is not a very major change done, not a new provision inserted. It's only this: state, as I have told you, state has a power to withdraw prosecution against anyone. And what I pointed out was misuse of this provision. When these politicians and ministers get their own cases withdrawn when they come to power. So in this, now the victim of that case, if I am a victim, I can go to the court and oppose that. Previously, I was not having the right. Now the amendment in section 360, new clause 360 gives the victim a right to be heard, and it is the obligation on the part of the court to hear the victim. Previously, there was no such requirement, and if state is withdrawing, even the court does not have any, because see, if state is there, accused is there. If state is withdrawing, obviously accused will not be opposing it. So the court will not have any remedy. They, most of the times court literally cannot do anything because state is withdrawing, accused is happy. So now the victim is brought into the picture so that at least he or she can oppose.
So those were the only questions by the participants. It was a very detailed and well explained session. Thank you so much for that, sir. Thank you for making time for bettering results and
Thank you
for
for
its
inviting me, and thank you
participants.
to all the participants for sparing this much, a little longer, but yes. And thank you for, and also apologies for my technical snag which happened during the in the middle of.
No, no worries, sir. Apologies for our technical glitches as well. Zoom sometimes tries to act up. Thank you so
Yeah, we
much.
are all learning.
Yes, sir. Thank you so much, sir. Thank you, participants. Hope you all have a great evening ahead. Thank you once again.